Hello, everybody. Welcome to our presentation. Our company is called Royal Ahold NV. This presentation is created by Team 6 by Genesis Gomez, Kushbu Kansara, Chloe Ann Prout, Andrew Walraven, and Ying Zhang. So the actual title of the court case is Public Employers Retirement Association of Colorado, Generic Trading of Philadelphia, LLC versus Deloitte and Touche, LLP. This case was finalized in 2009. The summary is, U.S. Food Service, USF, is a subsidiary of a Dutch corporation named Royal Ahold NV. And from the 1990s until 2003, Royal Ahold and USF both committed financial fraud against its investors. Royal Ahold overstated their revenue by misreporting about 5 joint venture revenues without having controlling interest in those joint ventures. Under US GAAP, companies can only consolidate their financial statements if they have controlling interest in a subsidiary, which is deemed to be a majority or 51% of all outstanding shares. Now, Deloitte performed their typical audit procedures, such as writing letters to the joint ventures to confirm the controlling interests that Royal Ahold had. However, Deloitte once received a side letter from one of the joint ventures, named Canica. Canica disagreed, stating that Royal Ahold did not actually have a controlling interest in their joint venture. In the case of U.S. Food Service, they also overstated their income by aggressively accounting for promotional allowances, otherwise known as vendor rebates. Vendor rebates are compensation vendors give to retailers to promote their products in their stores. The discovery of the aggressive accounting by Deloitte forced USF to adjust their income by $90 million. Additionally, Deloitte used written confirmation from vendors, and they also performed cash receipts tests to ensure accuracy and reliability in their financial statements. In the year 2000 and 2001, Deloitte tested about 65% to 73% of all promotional receivables. Deloitte, as well as the investors, were victims and were defrauded by Royal Ahold NV. In the end, the U.S. Court of Appeals affirmed to the lower courts that Deloitte lacked the censure to help perpetrate or continue the Ahold fraud, making them unliable.
Hi, Ying speaking. I will summarize the case from auditing issues to PSLRA. When I introduce the auditing issues in USF case, I want to introduce the auditing procedure first. Next slide. The Deloitte's auditor named Van was assigned to audit USF, requesting documents as well as meeting with USF. Van was supervised by Deloitte partner, Patricia, who asked Van to simplify the report to internal audit department, not telling the incorporation of the management. One of Van's objectives is to make sure the promotional allowance reported by USF is correct. In this case, Patricia failed to abide by integrity and honesty rule. Van is in an ethical dilemma, feeling pressure from his supervisor. Next slide. On the other side, the management from USF and CMO need to respond to Van's request. However, they didn't cooperate with Van. On the one hand, the management members failed to provide document and meeting with Van. On the other hand, CMO induced the vendor to overstay the PA and also conceal the contracts from Van, which really added difficulty in auditing work. Next slide. Then I would like to introduce the particularly standard in PSLRA. Once the allegation establishes the strong circumstantial evidence of conscious misbehavior or facts showing that the defendant had both a motive and opportunity to commit securities fraud, the signer is allowed to be pled. On the other hand, the plaintiff should meet a strong inference on signer standard. Next slide. However, how to define a strong inference is really a subjective issue. Supreme Court addressed 2 points. The first one is in line with PSLRA, and the second point provides us with a method to determine whether the inference is strong enough. That is to conduct a comparative method between the inference and the opposite views. Once the inference is stronger or more persuasive than the opposite views, the inference is adopted. Then there are other amendments on PSLRA. Let Andrew tell you more. Thank you.
Hi, Andrew here. I'm going to talk about the legal reasoning behind the court's decision. The PSLRA does not explicitly define what state of mind satisfies the center requirement under Rule 10b-5 of the Securities and Exchange Act of 1934. Luckily, we have some court opinions to help us out. In Ernst & Ernst v. Hochfelder, the Supreme Court placed a burden on the plaintiff to prove a strong inference that the defendant intended to deceive, manipulate, or defraud. Later, in Ottman v. Hanger Orthopedic Group, the definition of center was expanded to include recklessness. It defined recklessness as an act so highly unreasonable and such an extreme departure from the standard of ordinary care as to present a danger of misleading the plaintiff to the extent that the danger was either known to the defendant or so obvious that the defendant must have been aware of it. Note that this is more difficult to prove than negligence. Next slide. Now we come to the assessment of the joint venture fraud. The plaintiffs argued that the control letters and Ahold's oral representation were insufficient evidence of control under GAAP. The allegation, although true, does not provide a strong inference that Deloitte was complicit in the fraud or reckless. Since the plaintiff engaged in drafting secret side letters, we can infer that auditors at Deloitte did not know of the fraud. Deloitte was also not reckless because recklessness implies that the malfeasance is readily available. Again, the fact that Ahold produced these side letters can lead us to infer that Deloitte was unaware of the fraud. Recklessness was once defined to be so reckless as in their duties that the audit amounted to no audit at all. Deloitte did not ignore the control issues and were thus not reckless. Next slide. Next, the court had to assess the promotional allowances fraud. The plaintiffs argued here that the defendant was complicit when it ignored USF's lack of internal controls to track promotional allowance income. The court disagreed with this assertion because Deloitte brought this issue up multiple times to Ahold and USF management. Deloitte did not ignore the issue. They also did not rely only on USF representations. Deloitte obtained corroboration from third-party vendors for the figures presented by USF. It's not the auditor's fault that USF and its vendors lied to conceal important documents. Not discovering a lie or withheld information of documents does not constitute being knowingly complicit in a fraud or being reckless. Next slide. In conclusion, Ahold and USF concealed frauds and withheld important documents from Deloitte. the fact that Ahold and USF hid their malfeasance ensures that it was not readily available. Accountants can rest easy knowing that they will not be charged with securities fraud as long as they are not complicit in a fraud or so reckless as to ignore a malfeasance that is readily available. We will go to the questions now.
Hi everyone, my name is Khushbu, and as my team has already discussed about the case, I'm going to discuss the answers of questions 1 and 2. So let's see question 1. It asks us to justify whether Deloitte compromised its ethical and professional responsibilities in accepting evidence and explanations which were provided to them by their client for the joint venture and promotional allowances transactions. So to understand this question, we have to really understand the role of Deloitte, what role Deloitte played during the whole audit. So first of all, we have to see Deloitte's role in Ahold's joint venture fraud. Now, Deloitte was performing their role as external auditors, so they were required to maintain independence from their client. But Deloitte actually advised Ahold on how to account for their revenue consolidation under Dutch and US GAAP. So this really forces us to think that this incident might have compromised Deloitte's independence from their client. Secondly, Deloitte's auditors accepted Ahold management's representations and explanations about the control of joint ventures, and actually they should have asked for more sufficient, appropriate audit evidence. But instead of investigating further, they just accepted management's explanations and representation. Looking at Deloitte's role as USF's internal auditing service provider. Now, Deloitte was also performing the role as internal auditing service provider for USF. So when Deloitte asked the management of USF to produce certain documents, including vendor contracts, the management of USF refused to provide such documents. And besides, members of USF management also refused to meet with the internal auditor for the exit meetings. So, resultantly, as a result, Deloitte could not complete all the internal audit objectives. Now, these incidents should have created red flags for the auditors of Deloitte, but instead of investigating further, Deloitte just accepted USF management's failure and they just accepted this non cooperation. They did not investigate further, they did not ask more questions. Secondly, Deloitte's relationship with the internal audit as internal auditor also might have impaired their independence from their client because this might have created self-review threat for them. Now, looking at Deloitte's role as USF's external auditor. As external auditor, Deloitte was supposed to have proper confirmation procedures with the vendors of USF to actually substantiate the promotional allowance income. But their confirmation process was not sound, it was not proper because they accepted the confirmation via fax and they accepted this confirmation letters from the brokers and sales executives rather than accepting such confirmation letters from the financial officers. Moving over to question 2, is it really asks us to evaluate the decisions made by Deloitte from an ethical reasoning perspective, and we have to consider the effects of the decisions of Deloitte on the stakeholders. So here we have to understand Deloitte's duty while performing their audit as per auditing standards. So as per auditing standards, Deloitte was supposed to maintain independence from their clients. They had to maintain professional skepticism throughout the audit. They had to maintain competence, objectivity, and due care throughout the audit. Uh, but we have to think whether they actually perform their duty properly or not. As per the rule utilitarianism, Deloitte had duty to follow GAAP and GAS standards by following the substance of the rules and not just by following the letters or just the language. Looking at the stakeholders were public, investors, creditors, regulators, and employees. So Deloitte had their duty towards public, they had their duty towards the investors, but Deloitte was biased towards their clients' interests. They should not have been biased. They should have considered the interest of all the stakeholders and especially investors. But because they did not perform duty properly and with skepticism. That's why the investors had to suffer the losses. So this was all the impact of Deloitte's decisions on their stakeholders. Moving over to questions 3 and 4.
Thank you. For question 3, we will analyze critics' opinions of the PSLRA in respect to the fraud at Rayo Ahold and evaluate if we support the more liberal interpretation of proportional liability under PSLRA versus previous stricter standards under joint and several liability. In looking at the case of Royal Ahold, we can see how the requirement of Sainter led the court to conclude that Deloitte could not be held liable under the PSLRA. The court deemed that the evidence presented showed that Ahold and USF were conspiring with others to keep Deloitte in the dark about several important matters relating to the fraud. In regards to JV fraud, even though Deloitte could have requested stronger evidence of control of Ahold, this argument was outweighed by Ahold's secret side letters. The secret side letters provided evidence to the court that Deloitte was deceived, since Ahold would not have needed to create these side letters if Deloitte had acted with the intent to defraud. Furthermore, in regards to promotional allowances fraud, the court found that the PA fraud went undetected initially only because USF and its vendors conspired to lie to Deloitte and conceal important documents. Once again, Ahold and USF found themselves in the position where the wrongdoing seemed to outweigh claims against Deloitte. Next slide. So although critics say that the law has made it too easy to escape liability for securities fraud due to the passage of the PSLRA, we believe that it has brought more benefits than drawbacks. It has regulated the frivolous lawsuits that we would see with joint and several liability in the past. Legal costs were rising for audit firms and represented 9% of the revenues in 1991. Finally, plaintiffs facing bankruptcy and financial uncertainty could no longer count on filing a lawsuit against their auditors who had deep pockets. Next slide. So for question 4, we will explain the legal liability of auditors under SEC regulations and the teletabs ruling relied on by the court. We will include how Sainter is determined and share our opinion on the Commission's conclusion on the case. So auditors can be held liable under 2 classes of law. Those 2 classes are common law and statutory law. Under common law, auditors are liable to clients for breach of contract, where the accountant has a contractual obligation to the client, negligence, gross negligence, and fraud. This liability can also extend to third parties. Common law requires auditors to show evidence of exhibiting due care by adhering to generally accepted auditing standards and demonstrating that they performed audit services as others in their field would have. Under statutory law, auditors are liable under the Securities Act of 1933 and Securities Exchange Act of 1934. Under the Securities Act of 1933, accountants who assist in the preparation of a company's registration statements are civilly liable if the statement contains untrue statements of material facts, if it omits material facts required or regulation, or omits information that, if not given, makes the facts stated misleading. Under the Securities Exchange Act of 1934, the Act imposes liability on any person who makes a materially false or misleading statement in documents filed with the SEC. Next slide. In the case of Telebs Inc. versus Macro Issues and Rights, we explore the issue of establishing Sainter as central to the case. In order to establish Sainter, the court deemed the following 3 points necessary. The courts must accept all factual allegations in the complaint as true. Secondly, the courts must consider these complaints in its entirety and see if all the facts point to a strong inference of scienter. Finally, the court must account for any plausible opposing inference, and in the end, the inference of scienter must be the compelling argument. We do agree with the Commission's conclusion that Deloitte did not violate their legal obligations to shareholders. In the JV fraud, Deloitte asked Ahold to produce more evidence of control to justify compensation. And in the PA fraud, they asked USF for a number of documents to verify their PA numbers. Deloitte tried to voice their concerns to management in both cases, but management refused to provide the needed documentation for the audit. Ultimately, Deloitte were also the ones who discovered the fraud at Ahold and USF. Next slide. Thank you. That concludes our presentation.